Listen to me carefully, because what I'm about to tell you may save you from paying thousands of dollars you never legally owed. A few months ago, I sat across from a quiet, silver-haired gentleman named Mr. Howard. He was 79, a retired postal worker, the kind of man who never missed a bill in his life. He slid a paper across my desk with trembling hands and said, "I paid this because..." Well, it sounded serious. Well, the bill was for $642, for a service he never requested, from a company he had never heard of. And worst of all, he thought he had to pay it. He said, "I don't want trouble. I just wanted it handled." My heart sank, because I've heard that sentence too many times. Mr. Howard is smart, careful, proud. But fear of owing, fear of being chased, fear of being judged, made him panic. The paper used official language, bold letters, and threats buried in fine print, and like so many seniors across this country, he reached for his checkbook. But here's the twist. He did not legally owe that money. Not one penny. The law was entirely on his side. But no one told him. And that right there is the trap. This video, this message, this warning, it's for every senior who has ever looked at a bill and whispered, "I can't fight this. I don't understand this. What if they come after me? What if it hurts my credit? What if they're right and I'm wrong?" Let me tell you something as clearly as I can. After 15 years as a lawyer fighting to protect seniors' companies, collectors, and scammers all count on only thing: that you'll be too overwhelmed to push back, too polite to question them, too tired to argue, too scared to say no. But today, you're not alone. Today, I'm standing beside you. Because you deserve peace. You deserve clarity, and you deserve to know the truth. There are bills you do now have to pay. Ever. Over the next few minutes, I'm going to walk you through 7 bills seniors are pressured to pay but legally do and owe. And trust me, Bill Phase 7 is the one I see trapping seniors again and again because it looks the most legitimate, but is 100% built on manipulation. Before we get into the first one, I want you to hear this loud and clear. You are not causing trouble by asking questions. You are not being difficult. You are not being rude. You are defending your life savings. You can do this too. One question, one pause, one boundary at a time. Now let me take you to one of the most common, most fear-inducing, and most misunderstood types of bills. Surprise medical charges. It was a Thursday morning when Ellen, 72, diabetic, living alone, opened her mailbox expecting a birthday card from her niece. Instead, she found a $410 bill from a specialist she had never heard of. The paper listed a doctor she didn't remember seeing, at a hospital she thought was fully covered. She sat at her kitchen table for hours, turning the paper over and over like it might suddenly make sense. She told me later, "I don't even remember seeing that doctor." But what if not paying hurts my credit? What if insurance denies something else? And fear, confusion, shame. This is the invisible tax put on seniors, fear of the unknown. Here's what the law actually says. And I want you to breathe as you hear this. If you were treated in an emergency, if the hospital was in network, if you never signed a consent form agreeing to out of network treatment, then under protections like the No Surprises Act, you often do not owe that surprise bill at all. Not the $410, not even part of it. But medical billing departments count on silence. Insurance companies count on confusion, and hospitals count on the fact that most seniors don't challenge the charge. A study from the Kaiser Family Foundation found that nearly 2/3 of people never appeal medical bills. But over 50% of those who do appeal get the bill reduced or erased entirely. 50%. And let me tell you from years of fighting these cases, many surprise bills come from coding errors, duplicate charges, or a doctor who simply walked past you and billed your insurance as if they spent time with you. If a bill like this shows up in your mailbox, here's what you say. Can you show me the signed document where I agreed to this treatment and these fees? If they can't provide it, they cannot legally force you to pay. So slow down. Take a breath. Let your lawyer brain switch on. You have time. You have rights. You have options. And you can do this too. Now, let's move into something even more dangerous. Something that preys not on confusion, but on grief. This is the moment where loss meets manipulation, and it breaks my heart every time I see it happen. A week after burying her husband of 51 years, Judith picked up the phone to a voice that sounded official, stern, and cold. "Ma'am, we need you to take care of your husband's outstanding balance today, or we will have to move forward." Her hands shook so badly she almost dropped the phone. She whispered, "But I didn't sign anything." It was his card. This is how it starts for thousands of widows and widowers. Collectors know grief is the most vulnerable doorway into your wallet. They know you're overwhelmed. They know you're hurting. They know you're afraid of doing something wrong. And so they push. They use phrases like, "This needs immediate attention." "If you don't pay, there will be consequences." "We're only trying to help you avoid trouble." But here's the truth I want you to burn into your memory. Severs unless you sign the loan, open the account together, or are legally bound to the debt. You do not owe a deceased person's bills. Not as a spouse, not as a child, not as a sibling, not as a friend. Let me repeat that as your lawyer, you are not responsible for someone else's debt unless your signature is on the contract. Collectors blur this line on purpose. They send letters addressed to the estate, hoping you feel responsible. They call you, knowing you're grieving and too emotionally drained to argue. They speak as if your silence is an admission of guilt. But silence is not consent, and grief is not a legal obligation. I once helped a woman named Patricia, whose brother passed away after a long illness. She began receiving hospital collection notices with her name printed on the envelope. Even though she had never signed a thing, she felt shame, fear, and responsibility. She said, "He was my brother. I don't want his debts to hurt my credit." So we asked the collector a single question. "Can you show us the signed agreement with her name on it?" You should have heard how fast the tone changed. Suddenly, the collector wasn't so confident. Suddenly, the urgency disappeared. Suddenly, they had trouble locating the file. They had no proof. They had no legal ground. They had no right to ask her for money. The calls stopped. Completely. And I want you to understand something important, collectors. Talk with authority. But authority is not evidence. A raised voice is not a legal document. A threatening letter is not a contract. The Federal Trade Commission is crystal clear. Debt collectors cannot make you pay for someone else's debt unless you are legally tied to the account. Not even if you lived with them, you were married to them, you shared the same last name, you answered their phone, you handled their funeral, or you simply loved them deeply. Love does not equal liability. If a collector calls you demanding payment for a relative's debt, here is your script. I am requesting written proof that I am legally responsible for this debt. Until you provide that, I am not discussing this further. Then stop talking. You do not owe them explanations. You do not owe them your guilt. You do not owe them a cent. Many times, when you demand proof, they disappear because they know they have nothing. And let me address the emotional side, because this is where seniors suffer the most. When you've lost someone, you're not thinking clearly. You're trying to keep your world from collapsing. Collectors know this, and they exploit it. But you are allowed to grieve without being hunted financially. Hear me clearly. You are not dishonoring your loved one by protecting your own stability. You are not selfish for questioning a bill. You are not making trouble. By asking for proof, you are defending your peace. You are defending your savings. You are defending the life you worked so hard to build. You can do this, too. One letter, one question, one firm boundary. Now, in the next part, we're going to talk about a bill that hits even closer to home. When a friend, neighbor, or even family member claims you owe them money, but there's no paperwork to prove it. Get ready, because this one surprises people the most. Now let's talk about something that feels personal, painful, and often embarrassing. When someone you know suddenly claims you owe them money. No contracts. No receipts. No messages. Just a surprise accusation that shakes you to your core. It happened to Maria, a retired schoolteacher who always baked pies for her neighbors and never turned down a chance to help. One quiet Sunday afternoon, she received a text message from a woman down the street. "Hey, about that $500 you borrowed during the lockdown. When can I expect it?" Maria read the message 5 times. Her chest tightened. She remembered the neighbor bringing groceries when stores were crowded and dangerous. But not a single moment of borrowing money. Not a loan. Not a promise. Nothing. But suddenly, her generosity had been rewritten as a financial agreement. And this is where many seniors get trapped. Not legally, but emotionally. Because a false accusation hits your reputations. Will people think I'm dishonest? And memory. Am I forgetting something important? Dignities? I've never borrowed money in my life. Oh, scammers know this. Opportunistic neighbors know this. Even family members. Yes, even them. Know how to weaponize guilt. But here's the legal foundation you need, and I want you to carve it in stone. A claim is not proof. A memory is not a contract. A story is not a debt, Doc Cesar. If there is no written agreement, no text message stating loan terms, no bank transfer labeled as a loan, no signature, no dates, no repayment terms, then the person demanding money carries the burden of proof, not you. Let me give you a real example. I once represented a retired librarian named Ruth. Her former caregiver, someone she trusted deeply, began calling her out of nowhere, claiming Ruth borrowed $800 in cash 2 years earlier. There was no contract, no message, no record, no witnesses, no dates, no context, just pressure, just manipulation, just a threat. If you don't pay me, I will tell people you're forgetting things. You don't want that, do you? This is where fraud meets emotional abuse. So we asked one question. Can you show us written proof that a loan agreement ever existed? They had none. And when someone has no proof, they have no case. The calls stopped immediately, because without documentation, the law has nothing to enforce. Courts do not uphold vague promises from years ago. They do not enforce supposed handshake loans with no witnesses. They do not punish you for someone else's hope that you'll pay out of guilt. Let's make something very clear. Law's guilt is not a legally binding agreement. Fear is not a contract. Silence is not consent. Desas. If someone approaches you with money demands, here is exactly what you say. I don't recall this being a formal loan. If you believe I owe you money, please provide written proof of the agreement. If they can't, the conversation ends. You don't need to explain yourself. You don't need to defend your memory. You don't need to solve their financial problems. Remember, people who truly loan money keep records. People who give gifts don't ask for payback. People who manipulate rely on your kindness to stay silent. And I want to address something deeply human here. Many seniors fear being seen as forgetful. They fear causing conflict. They fear being talked about in the community. They fear losing relationships. And that fear is exactly what liars prey on. But you are allowed to defend yourself. You are allowed to ask for proof. You are allowed to protect your reputation and your wallet. You worked your whole life to build stability. You don't have to hand it away because someone is hoping you won't question them. You can do this. One boundary. One sentence. One moment of clarity. Now, in the next part, we're going to talk about a bill that shows up after you've moved, long after you've stopped using the service. But somehow you're still being charged. Utility companies depend on seniors being too tired or confused to fight back. But you're about to learn exactly how to stop them. I want you to listen very closely right now, because Bill Fay-5 is the one that tricks seniors every single day, and it makes me angrier than almost anything else on this list. It's called a surprise balance bill. And if you've ever received a medical bill that showed up months after your treatment. A bill that feels random, confusing, and completely unfair. There's a very good chance you don't owe a single penny of it. Let me explain this in plain English. When you go to the hospital, clinic, or ER, sometimes the doctor, the specialist, or even the lab that checks your blood or scans is considered out of network. But you didn't choose that doctor. You didn't shop around during an emergency. You didn't compare prices. You didn't pick who reads your X-ray at 2 a.m. Yet the system intentionally sends seniors a bill saying, "You owe the difference." Insurance didn't cover this part. This wasn't an approved provider. Let me tell you the truth, the billing department won't. If you didn't choose the provider, you don't owe the balance. Period. Federal law protects you from this. It's called the No Surprises Act. But the hospitals, they pray you don't know that. They bet on fear. They hope you'll just pay to make the bill go away. Let me tell you about Frank, one of my clients. Frank had chest pain and went to the ER. Insurance covered the emergency visit, just like it was supposed to. But 3 months later, a bill arrived in his mailbox for $800 for a doctor he never met, a doctor who wasn't in his network, a doctor he didn't choose. He panicked. His wife panicked. They almost paid it, until they called me. And here's what I told him. "Frank, you don't owe this. Throw it in a drawer and let me handle it." I contacted the hospital. I cited federal law. And you know what happened? Bill removed. Entire balance erased. $0 owed. No apology. No explanation. Just silence. Because they knew they were wrong. And Frank, he cried on the phone. He told me, "I feel like the system tried to steal from me." I didn't disagree. And he's not alone. I've had case after case after case. X-ray reading fees, lab fees, radiology fees, anesthesiologist fees, all sent illegally, all forgiven once challenged. Here's what I want seniors to understand. ISAS, if a bill shows up late, if the provider was chosen for you, if the service happened during an emergency, LIOUARE not responsible, the hospital wants you to feel confused. But confusion is their business model. Let me make it even simpler. If the bill surprises you, it's probably illegal. And here's something else nobody tells you. even if the bill collectors start calling, even if their letters look scary, even if they threaten your credit score. They often can't legally enforce the debt, because if the original charge was illegal, the entire chain of debt is illegal. But most seniors never push back. They don't know how. They don't know the law, and they're too afraid to challenge the hospital system. Please, hear me. You have more rights than you think. Now, before we move to Bill 86, let me leave you with this. If a medical bill shows up from out of nowhere, if it doesn't make sense, if you never approved the provider, don't take out your wallet. Don't panic. Don't sacrifice grocery money or medication money. Just hold the bill, breathe, and remember my words. If you didn't choose the person who treated you, you don't owe the balance. Hospitals hate when lawyers say this. But I'm not here to protect them. I'm here to protect you. And Bill 86, it makes me even angrier, because it's the one seniors pay quietly for years without realizing they can stop today. Let's talk about that next. We're almost at the end, and these last two bills are the ones that take money from seniors quietly, month after month, year after year. No fear, no panic, just slow, steady draining of your retirement income. Let's start with the one that nobody questions, even though it's costing seniors millions every year. Bill 860, the extended warranty and service contract trap. If you've ever bought a car, a TV, an appliance, a hearing aid, a medical device, you've heard this phrase. Do you want the extended protection plan? And the salesperson always makes it sound like you have to buy it. They lean in, lower their voice, and whisper, "You'll be responsible for all repair costs without this." It sounds scary, especially when you're older, especially when you're living on a fixed income. But let me tell you the truth as someone who has reviewed hundreds of these contracts. Most extended warranties are not worth the paper they're printed on. And if you bought one recently, there's a very good chance you can cancel it and get your money back. Yes, really. I'll tell you about Gloria. She was 72. She bought a refrigerator. At checkout, the salesperson pushed a 5-year extended warranty for $349. She didn't want it. She felt pressured. But she bought it anyway. A week later, her daughter brought her to my office. I looked at the contract and I almost laughed. The warranty covered nothing. Not the compressor. Not the cooling system. Not the electronics. Not even the parts most likely to break. So you know what I did? I canceled it. Full refund. Money back in Gloria's bank account in 5 business days. She asked me, how did they get away with selling this? And I told her the truth. Ours extended warranties prey on fear, and fear is big business. Listen carefully. If you bought a warranty within the last 30 to 90 days, you can usually cancel. If you never received the paperwork, you can cancel. If the service company changed owners, you can cancel. If the warranty didn't match what you were verbally promised, you can cancel. If you were pressured at checkout, you can dispute the charge with your bank. In other words, you have more rights than they want you to think. And now, let's talk about the final bill. The quietest one. The sneakiest one. The one every senior I meet is shocked to learn they can stop paying today. Bill 87. The forever subscription you don't need. This one hurts the most, because it targets seniors who simply want connection, safety, or convenience. I'm talking about magazine subscriptions, identity protection plans, antivirus programs, app subscriptions, credit monitoring services, monthly safety gadgets, old cable packages, premium memberships, and even some medical alert services. Here's the ugly truth. Licensed companies count on seniors forgetting to cancel, forgetting they ever signed up, forgetting what the service even does. I helped a gentleman named Walter last year. Sweet guy. Soft-spoken. 82 years old. He brought me a stack of monthly charges on his bank statement. There were 17 active subscriptions, some dating back 8 years. He didn't use them. He didn't remember signing up. Some of them billed him when he was in the hospital. He thought it would be impossible to cancel all of them. But here's the secret. Fast when you say the words cancel and refund unused months. Most companies give in. Fast. We canceled ALL 17 subscriptions. Walter got Verdal's 482 back. You should have seen the look on his face. He said, I feel like I just got a raise. And in a way, he did. Let me be blunt with you. You don't have to keep paying for things you don't use. You don't have to keep paying out of guilt. You don't have to keep paying because maybe it's important. You don't have to keep paying because you're afraid to call and cancel. You owe yourself peace. You owe yourself dignity. You owe yourself your own money. And if nobody ever told you this before, let me be the first to. You are allowed to say no. You are allowed to cancel. You are allowed to keep your money. Serás my final message to every senior watching this. If you've made it through all 7 bills, you now know what most people in EVR learn. The system is built on confusion, and confusion is how they profit. But knowledge is how you protect yourself. You deserve better. You deserve honesty. You deserve to keep the money you worked your whole life for. So starting today, not tomorrow, not someday, but totally, cancel what you don't need. Challenge what looks suspicious. Question every bill, and refuse to pay anything that feels wrong. Because you're not just a customer. You're not just an account number. You're not just another senior they can push around. You are a person, a provider, a parent, a grandparent, a fighter, and you deserve to be treated with respect. And if nobody has ever stood up for you before, I will. Always.